Chair recognizes the gentleman from California, Mr. Miller.
I thank the chair, and I yield myself 3 minutes.
The gentleman is recognized for 3 minutes.
Madam Speaker, members of the House, it's disgraceful but true that in much of the United States it's perfectly legal for employers to fire workers simply on the basis of their sexual orientation. I'm proud that today the House will vote on legislation to end this discrimination. It has no place in American society. The legislation we are considering was first introduced in the House in 1975, more than 30 years ago. And in the last 3 decades, gay, lesbian, and bisexual Americans have waged a courageous campaign for their workplace rights. I regret that they've had to wait so long for this vote, but I'm pleased that this historic day has finally arrived. The Employment Non-Discrimination Act ensures that employment decisions are based upon merit and performance and not prejudice. Federal law and the laws of 30 states permit employers to discriminate against employees based solely on their sexual orientation. In those 30 states, employers can fire, refuse to hire, demote, and refuse to promote employees on the basis of sexual orientation alone. Earlier this year, under Chairman Andrews' Health, Employment, Labor, Pension Subcommittee, heard testimonial from Michael Carney, a highly decorated police officer. Officer Carney was initially denied an opportunity to return to his job with the Springfield, Massachusetts Police Department because he was gay. Fortunately, Massachusetts is not one of the 30 states to deny these basic rights to gay workers, and Officer Carney was eventually able to return to his job. But that was not the case with Brooke Waits, who also testified at the hearing. Ms. Waits was fired from her job in telecommunications after her employer discovered that she was a lesbian. Since the state of Texas allows employers to fire workers based on sexual orientation, Ms. Waits had no recourse. She could not get her job back. It's hard to believe that fully qualified, capable individuals are being denied employment or fired from their jobs for these completely non-work-related reasons. And this is profoundly unfair and certainly un-American. Unless we act to outlaw this discrimination, millions of American workers will continue to live with the legitimate fear that they could be fired or denied a job or wind up unable to provide for themselves and their families. That is why it is essential that this Congress act to protect the rights of all workers, regardless of their sexual orientation. The Employment Non-Discrimination Act extends employment non-discrimination protections to gay, lesbian, bisexual, and heterosexual people. It prohibits employers and employment agencies and labor unions from using an individual's sexual orientation as a basis for employment decisions such as hiring and firing, promotion, or compensation. The bill prohibits employers from subjecting an individual to different standards of treatment based upon the individual's sexual orientation. The bill does not apply to businesses with less than 15 workers, private membership clubs, or the U.S. Armed Forces, and it does not apply to religious schools or other religious organizations. And I urge my colleagues to support this legislation, and I reserve the balance of my time. And I thank the chair.
The gentleman from California.
Thank you, Madam Speaker. I yield myself such time as I may consume.
The gentleman is recognized.
I rise in opposition to H.R. 3685, a proposal fraught with burdensome mandates, litigation traps, and constitutional concerns. This bill purports to prohibit discrimination in the workplace, a goal to which we are all committed. However, the reality of this bill's consequences does not match the rhetoric of its supporters. This bill departs from the long-standing framework and structure of the Civil Rights Act of 1964 by establishing standalone protections exclusively on the basis of sexual orientation. This new protected class would be afforded protections on the basis of vague and highly subjective measures that will cause confusion in the workplace and will result in costly litigation. For example, the bill extends protections on the basis of, I quote, perceived sexual orientation, a characteristic that is subjective by its very definition. How would an employer credibly refute such an accusation? This proposal could result in the exact opposite effect its supporters intend by creating new pressures on employers to consider and even document their employees' sexual orientation, actual or how it is perceived, in order to guard against litigation. This is a highly inappropriate infringement on employee privacy and would actually increase the consideration of such characteristics in the workplace. Also, any argument that the term perceived is already included in existing civil rights statutes is simply not true. This is a new term applied to a new situation, which will increase uncertainty and litigation. Even more broadly, this bill encroaches on two fundamental principles we hold dear: the free exercise of religion and preservation of the institution of marriage. H.R. 3685 is inconsistent with the long-standing religious exemption contained in Title VII of the Civil Rights Act. The bill adds additional layers of complexity in determining whether a religious organization is covered, setting up highly intrusive federal interference with the free expression of religion. We understand an amendment is to be offered later today that attempts to move closer to existing Title VII provisions. However, it remains unclear whether this amendment, which has been rewritten repeatedly, does enough to protect faith-based institutions. On the issue of marriage, the majority adds a provision that prevents employers from considering marital status as a job qualification, even though they have not provided any evidence that such a limitation is necessary. We are left to speculate that the real reason for this provision could be an attempt to undermine the fundamental rights of states to define, protect, and preserve the institution of marriage. The bill establishes new limitations on hiring practices only in those states that have prohibited same-sex marriage. By limiting these new restrictions to states that have defined marriage as an institution between one man and one woman, the bill has essentially identified traditional marriage as a form of discrimination. This bill then could become the first step in a radical effort to undermine state marriage laws. Madam Speaker, this bill has been introduced in various forms and fashions for some 3 decades. It has been introduced in the House 3 separate times this year alone. This is evidence of the inherent complexity that comes with such a far-reaching proposal. Later today, we will consider an amendment that seeks to broaden these new protections even further to purportedly cover discrimination based on gender identity, despite the fact that this provision was stripped from the bill before it was taken up in committee. There are serious practical and legal concerns with this amendment, and many questions remain unresolved. This is an effort to make an end run around the legislative process, considering the full scope of this proposal only when it is convenient for supporters. The bill before us is a sweeping departure from long-standing civil rights law, and its consequences will be far-reaching. A number of valid questions have been raised about how this bill will align with existing state and federal anti-discrimination policies and those policies that have been voluntarily adopted by employers. These questions remain unanswered. Because of that, I must oppose this bill and encourage my colleagues to do the same. I reserve the balance of my time.
The gentleman reserves his time. The gentleman from California.
I yield 3 minutes to the gentleman, Mr. Andrews from New Jersey, a member subcommittee that did a marvelous job in handling this legislation in committee. 3 minutes.
The gentleman from New Jersey is recognized for 3 minutes.
I ask unanimous consent to revise and extend my remarks.
Without objection.
Thank you, Madam Speaker. I thank my chairman and friend for yielding. We very often hear people say in this House that they oppose discrimination. Well, today there's a chance to do something more than just say that you oppose discrimination. You can vote against it. I listened to the questions raised by my friend from California, the ranking member of the full committee, and I'd like to address them. My friend says that there are burdensome new mandates imposed by this bill. That is not the case. If an employer has 15 or fewer employees, they're not covered by it at all. And there's really nothing burdensome about the idea that you can't refuse to hire or fire or mistreat someone because of their sexual orientation. That's no more of a burden than having the same rules based on race or religion or nationality. My friend says there are highly subjective measures, and he points to the use of the word perceived discrimination. He says that when we ban discrimination based on perception of sexual orientation, it creates too much confusion. The reality is that precisely the same legal concept has been part of our federal law since 1991 under the Americans with Disabilities Act, or actually prior to 1989 under the Americans with Disabilities Act. Listen to this. I know the word perceived is not in the ADA, but the legal concept is the same. One federal judge in New York heard a case, and that judge says that the case was based on harassment and discrimination based on her perceived disability. I'm not sure this judge is qualified, but most of the Senate does, because it was Judge Michael Mukasey, who's now the President's nominee to be Attorney General of the United States. This doesn't create new confusion. It simply restates an existing principle. On free exercise of religion, the gentleman from California is correct. There was some debate about the proper scope of the free exercise provisions in the underlying bill. Mr. Miller's amendment, which we'll hear shortly, imports precisely the same standard that has existed for the exercise of religion for the last 42 years under Title VII. The gentleman raises questions about marriage and says this is a radical attempt, or first step in a radical attempt to redefine marriage. Mr. Miller's amendment will make it precisely true that precisely the opposite is true. Mr. Miller's amendment will take the language that was approved by the House, signed by President Clinton in the Defense of Marriage Act, which defines for federal law purposes marriage as one man and one woman, and import it into this bill. Finally, the gentleman says this is a sweeping departure from civil rights laws. Nothing could be further from the truth. This is not a departure from civil rights laws. It's an inclusion of millions of Americans who should have been included for a very long time. It's a question of simple fairness. It's a question that says if you're a computer programmer or a bus driver or a carpenter, your job situation should be based upon how well you drive the bus or how well you program the computer, not on your sexual orientation. I yield back.
Gentleman from California.
This time, Madam Speaker, I'm happy to yield to the ranking member of the subcommittee involved, gentleman from Minnesota, Representative Kline, for 5 minutes.
Gentleman from Minnesota is recognized for 5 minutes.
Thank you, Madam Chair, and I thank my colleague, the gentleman from California, for yielding the time. Madam Chair, I rise today in opposition to the Employment Non-Discrimination Act, H.R. 3685. As the ranking member of the Health, Employment, Labor, and Pension Subcommittee, I've reviewed this legislation in several different forms over the last several weeks. I participated in debates and conversations that have brought this bill to the floor, and I have to report that this legislation is still flawed. The bill before us is drafted in such a way that it creates confusion and uncertainty. My colleagues offered a number of amendments to correct the inherent problems in this bill. Unfortunately, one critical amendment offered by Mr. Souder, removing the word perceived, was not accepted by the majority. My colleague has already introduced that point of confusion. I'd like to expand on it. This bill, and I quote, prohibits employers from discriminating against an individual because of an individual's actual or perceived sexual orientation, unquote. What does that mean? Perceived sexual orientation. We do not know because the bill fails to provide a definition. This raises a number of practical and legal concerns. The term perceived is overly broad, vague, and will inevitably lead to increased litigation. Lots of increased litigation. We cannot abdicate our constitutional duty by knowingly creating a law that is so vague that the courts must necessarily determine a definition. This is frankly a trial lawyer's dream. I will point out that in the course of our hearings, one of our colleagues did express faith in, quote, attorney world, unquote, to clarify this issue. Well, it is kind of funny. I just don't think that's a theme park that we want to visit. Employers may have difficulty in identifying non-inherent characteristics of a person, but could still be liable. Under this statute, employers would be accountable to prove that they did not make an employment decision based on either their own perception of an individual's sexual orientation or on that person's perception of themselves. I can see why attorney world could be called upon here. Employers would find themselves in the unenviable position of defending themselves in lawsuits by proving a negative, that they did not perceive the individual to be part of a newly protected class. Further, the term perceived does not appear in any other civil rights legislation. Let me be clear, we're not talking about the definition of gays, lesbians, and bisexuals. We're talking about those individuals that may be, quote, perceived to be such. The Civil Rights Act protects individuals on the basis of race, color, religion, sex, or national origin. Nowhere do we see the term perceived. Madam Chair, those who favor this bill presented on the floor today are motivated only by the end goals of this legislation and are failing to recognize the difficulty presented by vague terms and loose definitions. We are left with a bill that is filled with confusion and uncertainty. I would ask that my colleagues carefully consider the inherent problems in enforcement of this legislation and vote against H.R. 3685. Thank you, Madam Chair. I yield back the balance of my time.
The gentleman yields back his time. The gentleman from California.
I yield 3 minutes to the gentleman from Massachusetts, Mr. Frank, one of the pioneers of this legislation.
The gentleman from Massachusetts is recognized for 3 minutes.
I am grateful for the obscurity of the opposition's argument. I first filed a bill 35 years ago to say that you couldn't fire someone because he was gay or she was a lesbian. And at the time, people were very straightforward about their opposition. Times have changed. It is no longer fashionable to say that you ought to be able to discriminate against someone based on his or her sexual orientation. So we now get other arguments. Let me say this. I have heard a number of people raise this argument that the real problem is that it says perceived. I do not believe that a single one of them would change his or her position if we were to remove that. They are opposed to the notion that gay men and lesbians, people like me, should be allowed to prove themselves on the workplace without discrimination. But that's not a good argument to make. So we get perceived as the argument, and it is not a serious one. In the first place, this argument about having to defend a negative, it's wrong both legally and factually. The burden of proof is on the complainant. No employer has to prove a negative. It is the complainant who has the hard job of proving the positive. That's why historically statutes like this, well, every time we try to protect some people against discrimination, we go through 2 phases. First, beforehand, we get the most absurd exaggerations of the chaotic impact it will have. After the fact, they are rarely, unfortunately, enforced very vigorously. And by the way, if this were a problem, we'd have examples of it. 19 states have laws like this on the books. And how many examples have you had of the poor, befuddled employer who is so unable to perceive that he is put on the dock? None. This is a made-up issue, made up by people who don't want to confront the real issue. And here is the real issue. There are millions of our fellow citizens, Madam Speaker, gay or lesbian, who live in fear that they could be fired because they live in states where there is no such protection. And we have had real examples of that. And what we say today is, no, you can't be fired because of that. Why is perceived in there? Because otherwise you're opening a big loophole. By the way, this notion of perceived, it is so unusual that it's in the Americans with Disabilities Act and has been interpreted by several judges, Justice Alito, Judge McKeon, and Posner, 3 radicals who have enforced this. So let's not hide behind this semantic. That is not the genuine motivation for opposition to this bill on the part of anyone in this House. What they are saying is we don't want to protect working men and women from this. Madam Speaker, I was accused in the last campaign by a former member of this body of pursuing a radical homosexual agenda. Well, here it is in the House today, working, getting a job. That's what we are asking for. The right for people to go to work and be judged solely on how they work. Let's get rid of the semantic obscurantism.
Gentleman from California.
Happy now to yield to a member of the committee, Mr. Souder from Indiana. 3 minutes.
Gentleman from Indiana is recognized for 3 minutes.
I thank our distinguished ranking member. Perceived is in fact a real problem because many businesses simply won't go to court. Obviously, they'll negotiate or not bother with it. That's the type of intimidation of tactics that occur. But I'm against the underlying bill. I've never hidden that I'm against the underlying bill. I think it's a disaster for Christian bookstores, at least 85% of whom would fall under this, all sorts of Christian colleges, even with the well-intentioned amendment that certainly improves the bill that Mr. Miller's offering, Chairman Miller, it still doesn't fix underlying problems. One prominent attorney says that basically religious rights have to be trumped by sexual rights in the workplace, and that's the goal of this act, and that this gives religious rights a secondary status in our society to sexual rights. But I want to address one other thing, and I apologize for bringing direct politics into this, but in my last campaign, in the last 10 days of my campaign, a cookie cutter ad was dropped on me that started with pictures of Speaker Hastert and Jerry Lewis. Then a little clip was inserted into the ad that said Speaker Hastert visited my district and that I was proud to have him visit my district. Then pictures of Duke Cunningham came up, and then a picture of Bob Ney came up, then a picture of Mark Foley. Mark Foley's picture came out from the screen referring to friends of Mark Souder and said that Mark Souder has friends who have even had unnatural sex with minors, which was a smear on Mark Foley. Nothing was ever proven, even directly alleged that way. But for a party that ran cookie cutter ads in order to get the majority against me every half hour, referring to unnatural sex with minors that wasn't proven, and smeared me, Mark Foley, and others to stand down here, not allow a vote on gender because they wouldn't want to divide their party on the vote, not allow any direct votes on perceived, not allow any religious protection votes, and then to attack us for being intolerant when your party used that ad against me and others is a tad cute. I yield back.
Yields back his time. The gentleman from California.
I yield to the gentleman from California, Ms. Woolsey, for 1 minute.
Gentleman from California is recognized for
1.5 minutes, excuse me.
1.5 minutes.
Madam Chairwoman, I rise in support of H.R. 3685. Before I came to Congress, I was a human resources executive, and even then, during the 1970s, my company had a policy that prohibited discrimination based on sexual orientation. It boggles my mind that it has taken Congress this long to even try to catch up. I acknowledge that today's bill is a good start, but it is just a beginning. Many of my constituents want this legislation to include provisions that were in the original version of the bill and in the amendment that Representative Baldwin will introduce later today. I share their concern that legislation before us does not protect the transgendered people. Transgendered people are particularly subject to workplace discrimination, and nearly 1/2 of all transgendered people have reported employment discrimination at some point in their lives. My home state of California is one of a dozen states which already provides this basic liberty, freedom from discrimination based on gender identity. We have done so because we recognize that transgendered people, like all people, deserve protection. Today's bill is not perfect, but please know that today and every day, I commit to working with my colleagues to pass this bill and to keep up the fight to expand protection for all peoples. I yield back.